Good morning. Welcome to the 38th Annual Maryland Planning Commissioners Association Fall Conference. My name is Joe Griffiths. I'm the Local Assistance and Training Manager for the Maryland Department of Planning. We're looking forward to 3 days of citizen planner education and celebration of the important work of citizen planners. Before we get to our Open Meetings Act training, I'm going to start with a few poll questions to find out who we have in our audience. We're going to be running these at the beginning of every single day. All right. So first, what region of the state are you from or are you representing today at your attendance at the conference? Western Maryland, Southern Maryland, the Baltimore-Washington Metro region, the Upper Eastern Shore, or the Lower Eastern Shore? All right, let's show the results. Okay, so Southern Maryland's well represented as usual. And I do want to thank, gives me a good chance to thank Calvert County specifically. We were supposed to originally have this conference in Solomons, and we look forward to the future conference where we can. But they've been an excellent support and probably indicative of why we have such a strong Southern Maryland showing this morning. All right, let's move on to the next poll. So now, in addition to where you are, the geographic representation, you are attending today in which of the following roles? As a local planning board or commission member, local government staff, state government staff, perhaps a nonprofit representative, or other community stakeholder. A few more seconds. All right. Okay, so a lot of local government staff in attendance, but also well-represented local planning board or commission member. And I'll be interested to see as we go along each day how these change and see what our representation is. All right, well, again, thank you for joining us, but we're going to get right into the meat of the conference and start off with Frank Johnson and April Ishak to begin the Open Meetings Act training. Let me hide this and okay. Hey, Frank, can we bring up your presentation? Oh, give me a second. Okay, and I'm going to turn my camera off and I'm going to turn it over to Frank.
Okay, and I'm just gonna say welcome everybody, and I'm gonna turn my camera off too. And I believe April is also here, so let me do that and then start our presentation. So this is about complying with the Maryland's Open Meetings Act, but a good part of what we're going to talk about this morning will in fact be on closed meetings because that's part of complying and not closing a meeting without following certain rules. So a couple of things just to start with to keep in mind as we go through. Number one is, do be careful to follow specific rules on how to close. There are certain steps to follow. It's very important to follow those. In terms of about a closed meeting, there are certain rules that do allow you to close. Just because you can doesn't always mean that you should. For instance, to get attorney advice, you can close, but sometimes getting that advice can help inform the audience as well as all parties as to the reasons for your decision. So just getting the advice doesn't mean you have to close. On the other hand, certainly if there is a truly confidential issue, then there is an exception that, to the open meetings rules that do allow you to close, and you should in that case. Make sure, this is the third major point, get your own attorney advice on specific questions. You know, this is a general presentation, and certainly hopefully it does answer some general questions, but there are sometimes local rules that are even more stringent than the state Open Meetings Act. Sometimes there are local practices, and there can be additional reasons as well involved in this specific advice. So always take your own counsel's advice on these issues. The last point is good habits prevent a violation. That is following the rules, staying within an exception if there is an exception that allows you to close. Just doing that is on a routine basis. Again, good habits can prevent a problem when it counts. Next slide, please.
Frank, one second, I forgot to mention when I was introducing it. If you have questions, there's a questions tab in your control panel, and feel free to add those questions for the presenters. Now, I'm out of your way, Frank.
Not a problem. So just what are we going to try and do today? Well, we're going to talk about the Open Meetings Act and why a public body should comply. Of course, partly because that's what state law requires. But then what does this require of a public body? What does it govern? And there are some instances where it doesn't. We'll lay that out. What's it require before a meeting? You know, generally that's going to be some measure of notice and agenda. What's it require during a meeting? Generally trying to stay open if you can, and accessible to the public is what we mean by that. What actions does it require after a meeting? Well, minutes, typically. How is the act enforced? We'll have some discussion about that because there are actually two different routes. And then, much more important over the last couple of years, how can virtual or online meetings, as well as conference call, comply? They do. The goal is a meaningful opportunity to observe and making sure there's access. Next slide, please. So what we're talking about is the Open Meetings Act, and just so that you know what law it's based on, and we will cite as you go through, you'll see citations to the actual law. It's the General Provisions article, Title III of the Annotated Code of Maryland. Now, General Provisions doesn't sound exciting, but there are a lot of provisions in there that do govern the work of state and local government. For instance, Title IV, the one right after this, is the Public Information Act, which is always something to pay attention to. So, next slide, please. And is April here and ready to kick into this slide? Because if not, I will.
I don't see April yet. I messaged her, so it's you.
Okay. Well, I will move in. So as we start, there's an important overall policy statement, and this is something else to keep in mind. This goes to the slide we just had, what we're going to do, why to comply. Well, a big part of the Open Meetings Act is that there's a determination that public business needs to be performed in an open and public manner, and that citizens need to be allowed to observe performance in the deliberations. Now, that focus is on observation, not participation. So if somebody's going to say, well, I have an Open Meetings Act right to speak or offer my testimony, that's not to say they don't have that right, but that right's not going to be under the Open Meetings Act. The Open Meetings Act focuses on a meeting that's dealing with public business being open and handled in a public manner. Next slide, please. And actually, John Mathias, who's a former county attorney for Frederick County, kind of came up with, look, do these three things and you're always going to, I think we skipped a slide there. I think we do these three, there we are. Do these three things and your meetings will comply with the Open Meetings Act. So I had kind of already touched on this, but before, giving notice. And the rules basically require an agenda if that agenda is determined to be at the same time as the notice. What do you do during? Well, hold the meeting open to the public. Afterwards, minutes. And there's now a fourth because training requirements, including this training for those of you who are looking to be certified, that is now a requirement, and we'll talk about the different elements and how that has an impact on your operations as well. You know, as I'd said before, complying with the Open Meetings Act, if you do close, and we'll talk in a little bit more detail once we get into a couple of slides here, but the important thing is what I said about good habits, good practices. If you do close, always be careful to stay within your exception, because that's your limitation. If you go beyond that exception, could be a violation. Your closing right is only limited to the reasons you closed for in the first place, which is, as we'll discuss, that's why that vote to close identifying why does need to be in public. Next slide, please. Now, we've already implied this, but in-person meetings are not always required. And I think since the COVID-19 pandemic, we know that. A couple of years ago, early 2020, there were a lot of questions as to oh my goodness, what do we do? Because we can't do an in-person meeting even if we wanted to. Well, the idea is that there needs to be public access to observe, and we'll interpret observe to include or listen because conference calls are permitted. There's a site there on the page that in 2011, the Court of Special Appeals has held that conference calls are acceptable if they are accessible to the public, such that the public can hear all comments and discussion. Remember what we talked about, what the Open Meetings Act does, makes the meeting available to the public. And that's really both the board and the Maryland court system have held that conference calls are acceptable. Next slide, please. And so we believe that also means that virtual meetings are also acceptable as long as they meet the same standards. So if it's an electronic online Zoom, Skype, Google Hangouts, GoToMeeting, such as the platform here today, they can comply as long as there is a live feed, as long as they can be observed. There's a link where people can link in, the public. We do recommend very consistently keeping for a public meeting, such as a planning commission meeting, keeping that conference call option available. That can be for those without a computer or tablet access. That can also be where there's a computer problem. And that kind of a backup can even matter for members of your own board. So that conference call option can, you know, there are meetings that we have sometimes where you're right on the edge of the quorum. And if you lose a member, you no longer have a quorum and you can't really continue the meeting because there's no further business you can conduct. The conference call option, just keeping that in the background can save you in that instance. Certainly virtual meetings were needed during COVID-19, but given the broad access that allowed, we believe that this will be continuing in the future, and we've really made it a more integral part of this presentation, as you'll see. Next slide, please. So I had talked about the law before, that we're going to go through specific sections as just in terms of the title, so you have a sense of how we're walking through this. So as the law lays out open meetings, the first question is, well, it applies to public bodies, so what's a public body? Well, first of all, multi-member, that's not too hard to figure out. So at least two, but also means at least two who are not employed by the jurisdiction. What that means is if you have a staff meeting that is of employees of a department, that's not subject to the Open Meetings Act. Where, however, there are at least two or more members who are not employed, which could be members of the public, is what I'm getting at that point, it very well might be subject to Open Meetings Act rules. That's something to be aware of. Formal creation, so some sort of formality, creating the group. You know, it's not just an informal, oh, let's get together. You know, anytime somebody from the outside comes in to sit down and talk to folks, doesn't mean it's an open meeting. If there's some creation of the organization, which can include an executive order by the chief executive, which that is the mayor, or sometimes it's the in a commissioner form, it can be the chief commissioner. Committees and subcommittees can also be subject to the Open Meetings Act. That depends on how they're created. Sometimes they are created in the same formal way, sometimes in the same resolution saying this subcommittee is created. In that case, that subcommittee is also subject to the Open Meetings Act. It can include informally created public bodies. There doesn't always have to be the bylaw, rule, or resolution, but they have to be appointed formally in some way, and that would be by the chief executive or somebody who speaks directly to that chief executive. So there's still formality in that case, because it's not just a, oh, let's get together type of meeting. This is a formal creation. And it can include nominally private corporations, particularly those that are members can be appointed in the same way. There are private corporations that are actually established to assist governments, such as in operating or raising funding for parks. That can be true for public hospitals as well. And again, that's largely based on the same appointment process dealing with the informally created public bodies. Next slide, please. So the other part of activities governed. So if it's a public body, well, what does a public body do? Well, a meeting. So what's a meeting? What's a meeting that is subject to this act? A deliberation, consideration, or transaction of public business. And it's also such deliberation among a quorum. So a quorum counts anybody there, not, you know, you can't get around the room. You can't say, oh, I was in one side of the room or another side of the room to try to evade the act, which I think the Open Meetings Board may have seen some instances of that years and years ago. So it does require a quorum, however. If there are some counties now, I know in the fewer than in the past, but some of our commissioner counties would have only 3 county commissioners. Well, any 2 is a quorum. What that means is no 2 of them can sit down and deliberate or consider public business. If there are 5 commissioner members, well, 2 of them are not a quorum. So 2 could have that kind of a conversation. And certainly if it was a quorum, we'd say, look, that needs to be subject to the Open Meetings Act. But if it's not a quorum, it is not so subject. And that's just something very, very important to keep in mind. Now, it doesn't always mean an in-person meeting. Conference calls or any other method of simultaneous or contemporaneous interaction. And what do I mean by contemporaneous? Well, that can include electronic communications as well, where there is continued and interactive group deliberation, emphasis on deliberation on public business. So this isn't a matter of an email notice saying, hey, here's where the meeting's going to be held, or what do we want to include on the agenda. This is discussing an item of public business, which can be, what do we want the letter to say, going back and forth and deliberating. That kind of discussion, when you cross that line, that's when it is subject to the Open Meetings Act. And the easy way to say is, let's hold that discussion for the next open meeting. What's not included? Well, social gatherings, retreats, where no public business is discussed, but a retreat which does discuss public business, which typically a retreat among a quorum is going to be planning out elements of public business that doesn't necessarily mean the public needs to be part of the retreat and included in the retreat. That simply means there need to be a couple of seats there available for the public if it's an in-person meeting to sit down and observe. If it's a virtual meeting, then just as a regular public meeting, there needs to be a link for folks to observe. Again, the Open Meetings Act focuses on access. It does not focus on the deliberation itself. Next slide, please. And so, as I'd mentioned, electronic deliberations of public business, that means emails, texts. If it's simply transmitting information, that is, the meeting's going to be located here, this is what the agenda will include, that's really not a problem. If it's not among a quorum, that's not going to be a problem. But when you get into deliberations and the reply all emails back and forth, the board has found, in a case involving Talbot County, now it's been a couple of years ago, but did find that there was an electronic reply all ongoing email discussion based on the deliberation and discussion back and forth among members. And it went on for probably more than 24 hours, I believe, but it's clear that it was a continuous deliberation. Well, that was the first time the board found that an email exchange such as that can be considered an open meeting, or can be considered subject to the open meeting, and such discussion and deliberation may violate the act. The board had actually warned that this could happen for a couple of years before, and finally that was the instance where they did find a violation. So does that mean you can't use email? No. If we could stay there for a minute. I'm not done yet. But just the important thing, the next slide is fine, but the important thing is to know that there are some options you can try certainly just do a conference call after public notice and go ahead and have that discussion and let people hear the discussion. Individual emails to individual members without that deliberation, because if you take deliberation out of it, that's a big part of what the Open Meetings Act is intended to allow the people to observe. So if you take care of that, that's one way to handle it. But then if there becomes the need to deliberate, that needs to go in an open meeting. Also, delegating to staff is another option. So, if you're dealing with the draft of a letter, to say, look, does this draft, for instance, shooting an email to, say, 5 council members individually or board members, does this look okay? If everybody agrees individually, or simply delegate it to staff, can be one way to deal with it. So the next slide I have is slide 11, which has activities governed 3, the one right after this. There we go. Topics of discussion. So again, we've covered what's covered? Well, public bodies, their meetings, and then when they're having that meetings, what kind of functions are covered? Well, what is covered by the Act and requires it to be in an open meeting are advisory, legislative, quasi-legislative, and by quasi-legislative, we mean dealing with rules and regulations, budget, contract approvals. Again, the Act specifically lays that out, but those kinds of basic legislative functions, which could be for a council or for a planning commission, are all covered. What's excluded, that is not subject to the Act, and there are some elements. Administrative, which used to be called executive, and administrative might be, and we'll have a slide on this coming in a minute, how to run the meeting. Let's say that, let's say it's the first time you're doing a Zoom or a GoTo meeting, or let's say you've moved to a new platform or there's a new setup. That could be considered administrative. It doesn't require an open meeting as long as there's no discussion of public business during that administrative meeting. Judicial, which for our purposes, for the Planning Commission purposes, would be more quasi-judicial functions, But the problem for the Planning Commission is most of what is deliberately included, whether judicial, quasi-judicial or not, is any zoning matter or any other zoning matter is going to be included. So granting a license or a permit, which is a lot of what Planning Commission may consider, or any other zoning matter, which is really in the bailiwick of a Planning Commission, is going to be included. So the exclusions are fairly limited in terms of a Planning Commission, but they certainly are there. Next slide, please. And so to discuss a little bit about the administrative function, the reason why we have this slide is because it is one that is easily abused. At least that's the history. And it's often subject to complaints about abuse. Well, first of all, it can't be used to cover topics that fall within another defined function. So something can't be considered administrative that would otherwise be judicial or quasi-judicial or the like. And certainly, if it's subject to another exclusion, which we'll talk about those here shortly. The public body has to be applying existing law, not creating law or policy. And sometimes the problem when you get into an administrative discussion, well, how do we want to apply this? That does tend to lean a bit into saying, well, is that the best rule? That maybe we should change that rule. When you cross that line, it should be in an open meeting. A meeting such as that does close for an administrative function may be subject to the reporting requirement, especially if the meeting occurs in the midst of an otherwise open meeting. So if you're in the middle of an open meeting and saying, well, we need to close for an administrative function, well, then that is going to require a vote to close. And then there's going to be reporting afterwards, which is the second part of a closed meeting, what you do afterwards in terms of the minutes, reporting the date, time, and place, who was present, and what was discussed. And as I had mentioned before, the exclusion isn't related to confidentiality issues. Next slide, please. Now, I had mentioned before that the administrative function can cover virtual meeting preparation. I'd already laid some of this out, so I'm not going to read every word here, but if the administrative function exclusion is used in preparing for a virtual meeting, just realize it's limited to the practical and technical issues as to how to access. When you have new board members, new commission members, sometimes when you have a new program, there can be a question of, well, how are we going to access the meeting? How do we operate? How's the agenda going to run? Who's going to say what? That just makes sense to go through the details, and that can be, let's say, let's get together 15 minutes before the meeting, and then we'll go right into the meeting, and that can be limited to those kinds of administrative functions. Again, the emphasis is that exemption does not allow discussion on the creation of any public policy. Next slide, please. In terms of running a virtual meeting, there are some practicalities. Certainly since March of 2020, all of us who have been on boards or involved in boards and commissions have had to learn new ways of proceeding because we didn't have any other choice. And is April there? Then I will be finishing this slide and I will be turning the next, pardon me?
April is with us.
Okay, well, I'm going to be finishing this slide up, and then you all will get to hear another voice, and I know she will be very much welcomed. So for many of us now who have been proceeding, it's more of a habit, but when you're running a virtual meeting, you do need to understand, and these are practicalities. I'm not just talking about what the Open Meetings Act law provides, but to proceed with clear steps. What's that involve? Starting with a roll call that identifies who's there. That is the public body members who are there. Speakers ought to identify themselves before speaking. Again, operating in a deliberate way so that you're sure that the members of the public who have accessed the meeting can follow it. but also board members can follow it as well. The chair needs to be careful to recognize speakers by name. Raising hands before speaking can be helpful. Sometimes you can tell, but where you can bring everybody up on the screen, raising a hand can make it very easy. And motions just need to be very, very deliberate. And even voting member by member, that can take an extra couple of seconds, but that avoids confusion. And the whole idea is let's be deliberate, let's avoid confusion. And then, of course, the chair, going through the agenda in a deliberate way, announcing each new agenda item. Running a virtual meeting is a little different than being in person. I think for forever, we take certain things for granted, whereas you have to be much more careful and deliberate in a virtual public meeting. Next slide, please. We welcome April. This is yours.
Thank you. I apologize. I had some computer problems getting on this morning, and I will continue with slide 15. Several of things, and thank you for Frank for taking over while I was not occupied for the moment. So actions before a meeting, slide 15. What we need to do is looking at the public notice. That is an important feature. So you're going to look at the timing of the public notice. Generally, as a general effort, you need to have the timing as soon as you know when the meeting is. We've actually had situations where 24 hours before a meeting is fine. It depends on the circumstances. So they're going to look at the timing. Is it appropriate under the circumstances? Reasonably in advance of the meeting is basically the standard used, and that generally means that you need to look at, again, the surrounding circumstances. Is it not a, I apologize. Is it an emergency meeting, or is it a routine meeting? If it's a routine meeting, then you usually know in advance when your meetings are going to be. So if you have, say, a controversial topic coming up at a meeting and you hold off giving your notice for that particular meeting, that's going to look suspicious if there's somebody who challenges whether the notice was appropriate under those circumstances. If you are doing an emergency meeting or last minute meeting that you need to call, then there are special efforts that the board will look at. If you took special efforts, such as if you normally post your notice on a website, on your body's website, what else do you do? Do you post it on the front door? Do you, some communities use robocalls to get the word out. Some people use email, blast text messaging, things like that, to let people know that there is a meeting. So you would take whatever additional efforts you could use to make sure people know that there is a special meeting being called. I know in some boards, if they have a meeting coming up in a few days and they're in the middle of a public meeting, they'll do announcements at the end, and they'll say, by the way, such and such meeting is going to be held. So they'll even make a public announcement, a public statement, even in advance of a written notice, but a written notice will be required. What is the content of a written notice? That's also delineated in section 3302. You need the time, date, place, whether it's opened or whether it's going to be a vote to close the meeting. So we'll talk about that later, I believe, but if you vote to close a meeting, that vote needs to be taken in public. So the notice of that particular meeting, even though you're voting to close, that part of the meeting is open. The other thing you need to make available ahead of time is an agenda. So that will include the topics to be discussed and the items of business. It can be amended, but you need to make the agenda available in advance of the meeting. The method by which you do this, there's no requirement that it be posted on the website if you have one. However, if you are already doing that, then you should be consistent in your methodology. That's what the board would look at if somebody were to challenge whether the meeting complied with the Open Meetings Act, is whether you're being consistent in the application of how you get notice out there. Some bodies keep a public calendar available via the internet. That's also helpful for some folks. So next slide, please. So for virtual meetings, when you're not using a customary and usual practice for your meeting in person, And we saw this happen during the year and a half or so of COVID, where a lot of virtual meetings were held. So what you're going to do in that circumstance is provide additional information on how the public can access your meeting. Some of the virtual methods that were used over the past year included Zoom, YouTube access, Google Meets, Microsoft Teams, things like that. Frank and I both recommend using a conference call option because both the Open Meetings Compliance Board and the courts have held that a teleconference call that is accessible by a call-in number with an access code is an acceptable public access method to observe the deliberations. So having that as an option, in addition to whatever other virtual setting you have opted to use, is a pretty good, I would say, cover if anybody were to challenge. If you have that conference call option, call in, then that would cover you for Open Meetings Act accessibility. But advance notice is critical, and to the extent possible, use the same notice procedure you've already used. Again, if you're using a different method than you typically use, that might invite itself open to a challenge. So you want to make sure that you are using the similar and consistent methods. And then if it's a meeting on shorter notice, you're going to provide, extra care in making sure the notice gets out there. And also, if it's virtual, you're going to provide the additional information that I just mentioned. Next slide, please. So actions during a meeting. You're going to look at location. Is it a location that is suitable for the number of people that are going to be present at the meeting? You're going to look at public participation and of those people who are going to be present. Public participation is not required by the Act, but the folks are just required to observe the deliberations. That's all the Act covers. If your board or public body rules or regulations allow for public participation, that is a separate issue not governed by the Open Meetings Act. Whether you're going to allow tape recorders or cameras, the Open Meetings Act recommend, well, I shouldn't say the Act, but there are model rules that are recommended. There's actually a copy of those model rules on the Attorney General's website under the Open Government section of that website. So that is very helpful for bodies to use in adopting model rules. Also, are there going to be documents and communications referred to at the meeting? The public should have access to those as well, whether in beforehand or as handouts at the meeting. Sometimes they're available through a website if your body keeps their public documents on the website. Also, the discussion must be audible throughout the meeting. No quiet discussions amongst the public body members, which cannot be heard by the general public. And the reason is that the public can't tell if you're having deliberations regarding the matters beforehand, before them, the body. So if you're just asking the person sitting next to you at the meeting, what section are they referencing, or what document are we on, or did we do this on the agenda? Like just procedural things, that's not going to be an issue. And that happens fairly regularly, but you cannot have discussions regarding the matters before the body, except that they must be audible to the audience or the public participation. Next slide.
Okay, back to me here for a minute. And we've talked about a meeting being reasonably accessible. So what does that mean in terms of a virtual meeting? Reasonable means accessible to the community that's being served. So you have to figure out for the community we are speaking to, for our public community, are they going to have the means to, let's say, if you're using a Zoom platform or GoTo or a computer platform, does the community have reasonable access to computers? Most do. There may be some, however, that don't. And that's a matter of what you know. If you know they don't, and you then use a Zoom meeting, that means that meeting's not going to be accessible, and that means you know that it's not going to be accessible to the community. Now, April spoke to it as well, the recommendation of the conference call option, that's going to prevent that problem because almost everybody has at least access to a telephone, and often more than just a landline telephone nowadays. So the conference call, even as a backup, can help to underscore accessibility, give you that practical backup, and help to ensure open meetings compliance. But the main point is in terms of accessibility, and that may even be a matter of considering which platform to use, just give some thought over what will be accessible for the public, for our community. Next slide, please. And so in terms of what are we talking about more specifically in terms of access? Well, for a conference call, they needed a telephone number to call. For electronic online, that would be the access code. And often in providing that access code, there will be a telephone number to allow listening as an option. And often the electronic providers will know that occasionally there can be a computer failure. Again, to ensure public access, an online meeting can also be shown live through the internet, cable access, YouTube, or the like. And again, those are just some additional steps to ensure public access. And that is the goal overall of the Open Meetings Act. Next slide, please.
Okay, so what are some actions that you take during a meeting? Let's talk about in the context of closing a meeting. So there are specific exceptions to allow closure. As a general rule, your meeting is open anytime you're deliberating public business, but the Open Meetings Act provides certain exceptions to that. In order to go into a closed meeting, however, there are certain things that need to be done. So first, the chair of the meeting will complete a meaningful written closing statement, and it will cite the topic to be discussed, the reasons for excluding the public, and the chair must prepare and sign that. And so there is a sample form of that also on the Attorney General's website, which is very helpful. I highly recommend using it. I use that actually with my public bodies and assist them in preparing that. And the next thing, the body holds the public vote to close after the proper notice of the open session is given. So in other words, the notice of the meeting, as I discussed previously, that's required before the meeting, that goes out. And it says there's going to be an open meeting, or there'll be a meeting of this public body on this date, time, and place. And then you would state in that notice, but we're going to vote to close the meeting. And then that way the public can watch the actual vote to close in public. Once that is done, you must stay within the exception on the statement. When you close the meeting, you cannot go off on tangents and start discussing other public business. So the chair should ensure that or if there's a council present, should ensure that the body stays within the context of the specific exception listed on the closing statement. If you, the post-meeting disclosures, you can decide at that meeting what the post-meeting disclosures will be. It depends on what the reason was for closing or what the topic was for closing. Oftentimes we close meetings for litigation purposes or consulting with an attorney. Those are examples where you might want to be a little more careful what is stated publicly for not wanting to violate attorney-client privilege communications. But then on the other hand, the body may decide, okay, we're going to take this action and then we're going to vote on this in public, and this is going to be the reason. So you can make those decisions at the closed meeting and then decide what's going to be stated in the public meeting, either immediately after the closed session or at the next open meeting. There are 2 model closing statements on the Attorney General's website, as I mentioned. And in order to close a meeting, in order to be eligible to host or hold a closed meeting, you actually have to have at least one person on your public body designated who has been trained. So you need a designated trainee. And then if there's that person can't attend the closed meeting, then there's actually a checklist that can be used as well. And that checklist will go through what you need to do for the closed meeting. Again, if you do not have a designated trainee on your body, you cannot even hold a closed public meeting. Next slide, please. So what are the actions to take at a meeting? Again, this is with respect to the closed meeting. There are 15 exceptions. I'm going to just highlight a few of them, but they are all to be construed narrowly. To the extent you have a public body that tries to put everything into these exceptions, you're going to find yourself potentially being challenged that these were required to be open meetings. So one that is used fairly often are personnel matters. This regards typically individual employees or people who are going to be appointed, et cetera. And the public body wants to evaluate the qualifications, or if there's somebody that's having difficulty, you want to evaluate what the problem areas are, and you don't want to have that subject to public scrutiny because of the personnel issues and rights to privacy and things like that. So those are typically done in closed sessions. But while I say all this, these are opportunities to have a closed session. It doesn't mean you're required to hold these in closed session under the Open Meetings Act unless there are other areas of law that would apply or that you are concerned about. So the second one I mentioned already is receipt of legal advice, and as well as litigation, the third one. That typically involves legal counsel. It may involve staff reports on the status of litigation, potential litigation. And so that's something you may not want to have done in an open meeting. And those two are generally well-used exceptions to the Open Meetings Act. Real property acquisition is a little tricky. It does not involve the sale of property, only the acquisition. And basically, you know, in the context of, say, a municipality, which would be a public body, then you might not want other entities knowing that you're interested in acquiring property, because then that would unfortunately probably cause the price to increase. So there are certain confidential reasons why that real property acquisition is something you might want done in a closed session. Collective bargaining, similarly, you would want to keep that under wraps, because that involves collective bargaining with the union and negotiations that could have implications beyond what the actual negotiations are. Certain business development proposals, similarly, and public security measures and cybersecurity, which if those were identified, it could cause a risk to the information resources or network management. And then there are other laws, there are 6 others cited in the Act that require confidentiality. Next slide, please.
Okay, so the Open Meetings Act, as we've said a couple times before, does not require public participation. That's just not part of the Open Meetings Act. Focuses on access, and basically access for the public to observe public body deliberations on issues of public business. But we do recognize there are a number of instances where public participation may be otherwise required. That is, for a public hearing. This is part of the Planning Commissioners Association. You've got a conference going on for the next 3 days. Many of the plans and site plans and final plan decisions are going to be subject to public hearing requirements. They may be otherwise subject to open public comment. Some of that will depend on either other elements of state law or your own local laws. There can be other specific requirements as well, sometimes just force of habit, how they're normally handled. In terms of force of habit, consistent processes need to be followed to ensure equal access. So scheduling to allow comment in the order received, particularly in a virtual or online setting, is fair. In person, to have people either line up or speak in some reasonable order. In terms of a virtual meeting, sometimes allowing email comment either prior to the meeting or leaving the record open afterward, or both. Again, maximizing is a way to maximize public comment. Bear in mind the right of cross-examination, which does apply in some public commission deliberations. Let's say you have a plan that seems like a great idea, but then you may have some community members who are opposing to it, opposing that plan. There can be the right of cross-examination that applies. Remember what we were saying a couple of slides ago, that taking very deliberate steps proceeding clearly enough to identify who's speaking and what the rights are of everybody. Cross-examination issues may sound challenging, but if it does come up in a virtual setting, it's very workable. Certainly, cross-examination can be a challenge. Making sure that people have the right to go back and forth can be important, even in person. But either way, just bear in mind that that right can apply, and that would be, again, that's not part of the Open Meetings Act, that's just part of public participation. Next slide, please. And so in terms of the Act, we've been talking about how it applies and walking through the Open Meetings Act as part of Maryland law. And so now we're to the point, not before or during, now after what actions after a meeting are required, and basically those are meaningful minutes. There is a required timeliness, basically as soon as practicable after a meeting. In many cases, that's considered the next meeting, but sometimes minutes are not approved immediately after, right with the next meeting. Open session minutes under law generally do need to be available once they're approved, once they become minutes, on request without any redaction. They should be posted online if practicable, and there's a specific site there to the state law that requires that. If practicable means, well, if your municipality doesn't have a website or doesn't have a website with that kind of access, or if for whatever reason the process for doing so is just not workable, then that may not be practicable to post it. But the benefit of posting it is that if somebody wants to get a copy of the minutes, it's not a matter of them coming in and having to speak to staff and having to go through a formal process. It's a matter of go to the website and pull it down, and that's all that staff would need to do is make that quick referral. So there is the practicable allowing that to happen. There can be some good reasons to try to do that. Closed session minutes, well, because they're closed, they're sealed, but there is a public summary, and that public summary would generally include date, time, place, who was present, what was the voting record to close, the purpose, the citation allowing the closure, what was discussed, if there was any action taken. An easy way to make sure a closed meeting covers that, and again, remember what we were saying about good habits, is just to use the compliance checklist. Even where, and they're based on training availability, there are some instances where it may be required, but using it all the time just means you're much less likely to have even an unintended violation, and unintended violations can happen of the Open Meetings Act. A tape recording isn't the same as minutes. Many times there are tape recordings, and that's fine, and they can be available, and they're public records. But use of a live and streaming audio or video can be allowed for open session minutes. Generally, anybody who's had to go through those to look for something in the minutes doesn't recommend them, because minutes, minutes are intended to simply cover actions taken. Probably the best minutes are maybe a half page or a page. So it's fairly easy to identify what happened. Live and streaming audio would if they're used as in place of the minutes, that can require listening to that entire audio, and that just takes time. That's just a big time factor. Next slide, please. And so in terms of, I'd already touched on some of this, is what the minutes of the next open meeting need to include when you've had a closed meeting, but this just runs down in a very clear way. Look, these are the things you need to cover. Purpose, which is not the same as the citation. The purpose describes what you were actually doing. Then the next thing is the citation. What were the votes? And then, as I had said earlier, date, time, place, persons present. Again, there is a template on the Attorney General's website, and the only exception, which is kind of an exception, would be that if an open meeting is closed for the administrative function, then the minutes would include some of those same 7 topics, but basically just the subject matter, date, time, and place, and who was present. Because otherwise, the administrative function isn't even subject to the Open Meetings Act. The only reason why you're having to report on it is because the meeting was closed for that purpose in the midst of an open meeting. Next slide, please.
So again, to continue with what action should be taken after a meeting, one is you were going to need a copy of your notice. That should be kept under the Open Meetings Act for 1 year. Now, these are just under the Open Meetings Act. There may be other record retention requirements that your body is required to comply with. So those are separate and apart from the Open Meetings Act. But for purposes of Open Meetings Act, the other thing you'll need are your minutes and tape recordings. Minimum of 5 years. I would recommend longer. Sometimes that's the only evidence of any action that your public body has taken, so it's a good historical record as well. Sealed minutes, at least 1 year. That would be your closed meeting minutes, or the ones that are kept confidential. Closing statements, about 1 year. I don't know if that one's specifically required, but that's the recommended time period. And then there's I mentioned archiving requirements. What other laws apply? Those are the ones you follow. And then as far as access, they should be open to inspection at the office on request. And as Frank mentioned, the minutes should be posted online to the extent practicable. I have found it very useful. And if something is subject to public inspection anyway, and it's something such as minutes for a public body, having them available online, at least for a certain period of time, it really is helpful, and it reduces the requests for such documents that your staff might otherwise need to respond to. So in that sense, it actually helps everybody to have them available. If they're already going to have to be produced anyway for inspection, you may as well make them as available as possible. That would be my recommendation. Next slide, please. So after all is said and done, what happens if your body, your public body, or your agency or your municipality is found to be in violation of the Open Meetings Act, or if you're somebody who is concerned that a public body has violated the Open Meetings Act? What are the remedies? There are basically two routes to take. One is the Open Meetings Compliance Board is able to provide an advisory opinion, and that's provided in sections 3204 to 3212. When the Open Meetings Act finds a violation, then the public body must summarize the opinion at the next public meeting, sign it, and return it to the Compliance Board. That is the extent of the Compliance Board enforcement mechanism. It is basically kind of like basically a public embarrassment, and it keeps the public bodies in check, that they want to make sure they're going through compliance. So what you'll see is once a body is found to be in violation, they tend to correct their actions so that whatever the issue was, that particular issue is resolved. So it does have a good enforcement effect after the fact. And sometimes during a complaint process, a public body will consult with counsel, and then the legal counsel will look at it and say, well, we need to tighten up some practices here. And in that context, in some borderline cases, when I was on the Open Meetings Compliance Board, we found that it was a borderline case to begin with, but because we were pleased with the actions taken by the Compliance Board, sometimes those comments would be included in the opinion of the Compliance Board to encourage other public bodies who may be having similar difficulties in taking the steps to fix the issues. So we see it more as a remediation type of provision. And then the other method, if you wanted to go that way, would be to go to the circuit court. They have jurisdiction. The circuit court can issue orders. They could overturn a public body's action. They can assess penalty, and they can award attorney's fees. If there is an Open Meeting Compliance Board opinion in a particular case, the court could take the opinion and follow it, or it could reject it and come up with its own decision. But that is another action. Typically, we don't see too many circuit court actions, and in part that is because unless you can get an award of attorney's fees shifting the cost of the case, it is probably going to be fairly expensive to bring that from a legal fee standpoint. So I think that's probably the reason we don't see too many, but there have been a few opinions that have helped guide litigants on both sides in what is interpretive guidance on the Open Meetings Compliance, the Open Meetings Act. Next slide, please. So what are the training requirements? Well, I mentioned before that each public body is required to have a designated trainee. That means each designated trainee is required to receive training. So that training must be take within 90 days of the designation. And if you receive training before October 1st, 2013, that training does not qualify because there have been changes in the law since then. And if the designee is no longer on your public body, then the public body would need to designate a new person. So with that said, I believe the training today satisfies your training requirement, and you can be the trainee, designated trainee for the public body that you will be on. Or you can then assist people in finding ways where they can get their training in a program such as this, and that way you can satisfy this requirement. Next slide, please.
Yeah, and this is an additional training requirement. What the General Assembly basically passed one training requirement, and then a few years later added in another one. This is similar, except for the fact that this requires not staff or somebody associated with the board, but this actually does require a board member to be designated and who does attend and go through an open meetings training, such as what you're getting today. If there isn't anybody designated, that public body, whether it be planning commission or city or town council, can't meet in a closed session. So they have to designate somebody. Now, if they designate somebody and that particular member can't attend, then that's when I had mentioned earlier, using a specific form, you need to use the Attorney General's compliance checklist and attach it to the open session minutes. But remember the rule I talked about at the beginning. Good habits prevent a problem. Guess what? If every time you do a closed meeting, and for a planning commission, in fact, you may very rarely need to, using the compliance checklist, whether you have a designated member present or not, means you are reducing the chance that you're going to commit a violation, even an inadvertent violation, because they can happen. Public bodies should retain their own proof, certainly. The Training Commission does not want to receive evidence that you all have training. A couple of things to keep in mind. The designation is not necessarily limited to only one member. In fact, every member can be designated. And if that's the case, then you have alternatives. And or certainly if a couple of members are designated to receive the training, I mean, typically everybody does. Most members of the board, given the multiple different options, for instance, this training can be taken online at the Attorney General's website, but there are other options during the year that are also available. And I know because April and I are often giving them and making them available in different ways. So having more than one member designated means that if at least one of those designated members attends, you're not going to have a problem. But making sure everybody, that's another way to avoid an inadvertent violation or a violation of any kind, at least of the Open Meetings Act, by making sure your public body members are trained, that they're aware of what is required and why are we going through these steps, both to close a meeting if it's necessary. Why are we making sure an agenda goes out along with the notice? What about this public notice ahead of time? Folks understand there's a lot less of a concern. Next slide, please. And this is just a general one that I think April and I can both speak to in terms of common causes of violations. What are some steps to avoid complaints? making sure that there's a response when there is a complaint, because in some cases there have been local governments and bodies that have not responded. Well, when that happens, then the Open Meetings Compliance Board simply has to make a decision on the record, and that may not favor you if you haven't responded. But April, having been on the board, I think can speak well to a lot of these as well.
Yeah, I would say there's two sides to every story. So sometimes actions that might look as if they're in violation from a complaint that somebody might have submitted, when the other side responds and shows additional information that was not available to us from the beginning, then we can look at the whole picture and say, well, under these circumstances, there was not a violation. Or alternatively, we had one situation where the response was, we didn't violate the act because these deliberations were whatever, and the deliberation was done in a situation where there was not public notice and not public access to the deliberation, because most of the deliberation was done by a few, I think it was near simultaneous emails over the course of a 24 to 48 hour period, asking for approval to take a certain position. And that, the whole context of that case was really, from the board's perspective, having sat on that one, was the use of the word deliberation was really important, because that's exactly what the Open Meetings Act is supposed to allow the public to observe. So those types of things, using email to have deliberations of any kind, if it involves a quorum of the public body, is very dangerous in the Open Meetings Act context. I think that's where some public bodies get themselves into trouble, and that could have an impact in the Planning Commission area. If you do pre-meeting communications by email, it should be limited to just dissemination of information that is to be reviewed with attachments, and perhaps, meeting times and dates and availability, but certainly should not include a discussion or deliberation of the matters that are going to be coming before the Planning Commission for consideration. So that would be an example. Make sure you keep the deliberative part of the process, or the policy making part of the process, separate from anything that's merely just delivering information or finding out accessibility for meeting dates, etc. So that's, I would definitely look at that as an issue to be concerned about, because that's where the more recent violations have kind of come out of that, the modern use of electronic communications.
Yeah, in terms of some steps to avoid a problem, two key ones can be, certainly following the steps we've outlined and having somebody responsible, but making sure to orient, making sure new members of your boards go through some measure of orientation. That doesn't necessarily say okay, we've got to get you scheduled for a formal training, but somebody to go over some of what is involved here. They can certainly go online to the Attorney General's website and go through the training that's provided there, but making sure there's an orientation so that not only new members know how your board operates, but also some of the key Open Meetings Act requirements, and then designating staff or somebody to just make sure these steps are complied with. And sometimes, we've talked about closing a meeting for a certain specific reason. That's required. If you're going to close a meeting, you've got to have a reason, and you've got to stick to that reason, and you can't go beyond it. And sometimes there is the temptation to say, well, now that we're in closed session, who's going to know? Well, those who think that things don't get out just because a meeting's handled in a closed setting, if there's more than one person involved, there's always a very good chance that the information will somehow get out. But the problem is the information will get out and create more rumors. Again, the key is, let's just avoid a violation. If you touch on another subject, let's say the Planning Commission had to close for a staffing issue, so it was due to the personnel exception, and then something else came up about some element of a site plan or something else, to say, well, that might be litigation. Well, you would have to reopen and then close again if litigation was not noted in your reason for closing. And again, it's important to have somebody designated. And that's really, I think that's the General Assembly's idea, and having somebody designated to get the training, because the hope is that person will then have that background and be able to come forward and say, look, we're beyond the line, and we need to go back out into open session. If we want to close again, we can. Better approach would be, let's put it on the agenda, and at the next meeting we have, then we can walk through the process. Trying to sometimes do things in a quick and a hasty manner can also be a problem, particularly when you're dealing with requirements of the Open Meetings Act. Just remember, there are steps before, during, and after on top of the overall training requirements for everybody. So next slide, unless April, if you've got any more on this. If not, next slide.
No, I was just gonna add that when you look at the overall purpose of the Open Meetings Act, it really is to allow the public to observe the deliberations. And I think sometimes folks on the in general, they want to be defensive about their acts they're taking, and there's this tendency to want to close it off and not let anybody see what they're doing. So there's this kind of tension of wanting to do your job and get it done efficiently, and a concern that there's public observation. But I really do believe that my observation is that when you do the Public Meeting Act requirements properly, it actually builds a level of trust between the public and the public body, and it actually lends to more efficiency and less distrust. So I think allowing the public to see the public deliberations is really the true purpose of it, and as long as that's kept at the forefront, and then you take the steps necessary, it will go a long way into not really having any issues. And I'm done. You can go to the next slide. Thanks.
And these are just, we've talked about the Attorney General website. That's how to get there. I don't know that there are big questions now on virtual meetings, but there is an FAQ on the Maryland Municipal website. We've talked about the online classes. The Open Meetings Act manual, which actually has several chapters, is actually quite a book where there's a major questions to go through, and that cites both Maryland court decisions and Open Meetings Act Compliance Board decisions. This refers to the 9th edition. We will be updating that to refer to the 10th edition that Ann McNeil had been the Assistant Attorney General advising the board. She retired earlier this year, and before her retirement, early 2021, she did a 10th edition of the Open Meetings Act manual. So that is fully up to date, and where there are major questions can be very helpful. Next slide, please. And this is just the link for the evaluation, and I think John may be able to come in and give you more information on that, but this is the evaluation and also the verification form for this core class. Okay.
Well, Frank, this is Joe. We can send.
Oh, I'm sorry.
We can send this I will send this presentation to all attendees later this afternoon, and then they'll have access to this link.
Yeah, that was the recommendation, so that'll work.
Okay, well, we do. Oh, John just shared it with everybody as well. Thanks, John. Well, we do have quite a few questions in the that were submitted. If April and Frank, if you have no other items to present, if you could turn your cameras on, and we'll have some time for Q&A.
Okay.
Okay, give me a second. I'm gonna close this. Stop showing screen. All right. So let me see here. All right. So what is considered the best what is considered best practice for advanced public notice?
You want to take that one, Frank?
I can. I mean, as far in advance as you know. Now, there's a difference between notice and agenda. The notice is saying we're going to have a meeting, and it's saying where and when, and what the general topics are going to be, such as it's going to be a city or a town council meeting, or it's going to be a planning commission meeting. In most cases, a planning commission or other municipal commissions will meet on a regular basis, so simply posting that every first Tuesday or every first Monday at 7:30 we're meeting, and if right now it's virtual, saying that on the website, or specifying where. In terms of the notice, the old-fashioned way of providing notice of a specific meeting to say not only do we regularly meet, but we have this specific meeting coming up, has been by posting at town or city hall, but using the website for that purpose as well. In terms of how far in advance, the most specific requirement, I think we were talking about section 302 for general notice. 302.1 of the Open Meetings Act talks about agenda and talks about that. That should be attached with the notice if it's determined at that time, but at least within 24 hours before the meeting. To me, a couple of days in advance is usually a reasonable way, meaning that the notice and the agenda to go out a few days ahead, to be posted, to be available, makes sense. That way there's no question of being unreasonable. Follow your consistent practices, and bear in mind, in terms of agendas, it's not final even in the midst of the meeting, because an agenda can be changed in the midst of a meeting depending on who's there, preferences of the board, sometimes even preferences of the chair. The agenda is simply laying out, here's what we expect to be the specific topics.
Okay. Thank you, Frank. I know there's some issues with the link not working. I tried from another source. Hopefully, please let us know if that link is working. Okay, next question. Does the public or do citizens impacted by a project have the right to ask questions and voice their points of view, and any rights beyond just sitting and listening during open meetings?
Well, I would say for the Open Meetings Act, no. But under provisions dealing with planning commissions and plans and processes, and April will certainly speak to this as well, that would be a separate requirement. And that's why we did touch on that there can be some requirements. And the main thing is just make sure you have consistent processes so that folks know when they can speak, how, and even how long. You know, consistent limitation can be any public comment, 3 minutes apiece, can get started now. Yeah. But again, that's not under the Open Meetings Act. That would be under a separate planning requirement.
Right, and I would add that the overlap with the Open Meetings Act, there was one opinion that we had done while I was on the Open Meetings Compliance Board, and it involved a change in the policies and procedures of public participation and public comment. And because that was a deliberation over a policy and procedure of that particular public body, the change in that was required to be done in an open meeting and not in a closed meeting, and nor was it considered an administrative decision because it was changing the process by which the board conducted its public meeting. So if your board or your public body or your planning commission is going to change the manner in which the public participates, if that's the rule under which it participates, to the extent you can do that legislatively, I'm not sure, but to the extent you can alter those participating rules, then the decision to do that should be done at a public meeting. If you don't, you could run into an open meeting problem with respect to that specific decision making. Does that make sense? Did you understand what I said, Frank? Because that was one particular case.
Right. I mean, you're speaking to a case where that process was a matter of public policy.
Mm-hmm.
And that, if you're establishing that process, that should be considered public business.
Right. And then an example today might be with the school board scenario where school boards might want to limit people's participation now because of different reasons. And so they just make a blanket decision, but they don't really make that decision in public. And I know one public body I was involved with, we had 2 periods during an open meeting where citizens could comment, and we consolidated that into one time period so that it was pushed up earlier in the meeting. And that discussion was held in an open meeting. So again, if it's going to affect your rules and regulations as a matter of policy, that particular decision should be done in an open meeting. So I just wanted to make that distinction.
Thank you. The next question is very specific to the slide, and I'm trying to figure out exactly which rules they're discussing, but the question was, can a link to the website for the model rules be provided? It was asked at 9:38, so I'm trying to remember. Maybe April or Frank, you know specific rules they're discussing?
Yeah, that would be probably that would be on the Attorney General, so it would be marylandattorneygeneral.gov. And it's going to be under the open meeting, open government. And then I believe is it model rules for, there should be a tab for model rules for tape recording. Is that where it's located, Frank? That's where I remember seeing it last.
Yeah. Mm-hmm. It should be there. The rules for recording, the general focus is to avoid disruption. And I will say that is considered less of an issue now that somebody can just turn on their cell phone or their iPhone and do recording. And if it's in the midst of a public meeting, if it's not disruptive, it would be hard for any rule to prevent that because it's in the middle of an open meeting anyway. That is generally what the model rules try to do. And this is going back to the time when if something's going to be recorded, you'd actually need to have a physical camera there or an actual more noticeable tape recorder as opposed to what we see now where recordings can be done with very little effort and therefore very little arguable disruption to the public business. But the rules should be have in the past been on the site and should still be available.
I just clicked on it actually, so it's under the Maryland Open Meetings Act tab, and then if you look under sample forms and checklists, it'll say one of the links is meeting rules. It's under meeting rules.
Okay.
We can send that out to attendees. I might follow up with you, April and Frank, to make sure I'm getting to the right location.
Okay.
Make sure we share that link.
It's the second to last page of the presentation is the overall link that then has all of those other pages because we referenced the AG's website already.
And I will say that website is also very helpful because it also has the Open Meetings Compliance Board opinions that are easily, they're easy to find on there. There's a topic index, and it can help you even in formulating a response to a complaint or in determining whether or not your body is in compliance with the Open Meetings Board and whether you need to, tighten your procedures.
Thank you. Okay. Can commissioners discuss things over a cell phone, through texting, or through emails during a live ongoing meeting? The public cannot hear these because they don't know it is going on.
Well, I mean, I would generally and what we were saying was making sure that deliberations and discussions are vocal so that everybody can hear them. That was meant to include discouraging texting behind the scenes, because whether it's whispering quietly to somebody next to you or texting, that's excluding that discussion from the public being able to observe that deliberation. Now, if the text is from one person to another, again, it's not a text in the middle of a quorum. It's not a text involving a quorum necessarily, but it certainly could be. It's easy enough to be. And the interesting thing, April can say whether or not, I don't believe there's been an open meetings compliance board decision on it, but I could see one coming. If in the midst of an open meeting, you had a second one going on by text, if that involves a quorum and it involves deliberation of public business, they've already said that can be considered a violation. Again, if those items are not being laid out for the deliberation. Now, if it's a matter of who's speaking first, that's not going to be a problem. The other thing I will say is when we've given these presentations in the past, there are a number of local governments that have come down with rules that basically say in the middle of a public meeting, no texting amongst each other. Now, I'm not going to speak to how that's enforced, but that's reflecting a concern with that problem, and just saying, again, as we presented, keep the discussions open so that everybody can hear them.
There was one opinion, open meetings complaint opinion that I was involved with right before I left the board, and it did involve texting while I believe it was a municipal government, or it could have been a school board, I can't remember, but they were on the, they were at a meeting, they were deliberating, and even though there were text messages going on and we could not confirm whether it was amongst a quorum of the body, people on the public body, they were involving the particular issue that was being voted on at that moment. So our concern was, and this is what we stated in the opinion, we did not find a violation at that particular meeting, but we said it could be because it involved the very thing they were voting on, and it could have affected the deliberation. Now, the reason why we came down that there was no violation is because we couldn't tell if the persons were even they were not responding. The texts were incoming, but there was no response, and there was no indication in the voting that impacted the voting at all, that these were matters that were already discussed, you know, in the open. But had it been amongst a quorum of individuals while they were in session, I mean, that would be a definite problem. And I would caution anybody from using text messaging to have any discussions while on the dais while there's a particular issue before that particular body. So that is a concern. There's it's not an easy thing to police, but I guess if the right person complains and gets access to those records, it could create a problem. And then if that were to happen, I would believe that the legislature then would come down with some more specific regulations governing this area. So far, they have not come down with more strict regulations in this electronic communication area because the board has been able to set forth adequate guidance for people. But if that guidance is no longer applicable in an easy manner for these electronic communications, I believe the legislature will amend the act to cover these areas. So it's really in the public body's best interest to allow, you know, to look at the policies that the act is trying to promote and guide your actions accordingly, because there could be other things coming down the pike that will make it more restrictive.
Yeah, and one other thing to keep in mind in terms of texting and email, you know, we talked about this being Title 3 of the General Provisions article of the Annotated Code, and the Public Information Act is Title 4. And the reason why I just kind of touched on that a little bit is the reality is that texts and emails, even on your own phone and your own email, if it's on public business, could very well be subject to the Public Information Act. And, you know, the point there is, having been at one time on now I advise, but at one point I was an elected official and on a board, and this was years ago, prior to lots of concern with email. But the reality is when you send emails around with different comments and different opinions, the reality is, are you going to be comfortable with that being front page of the Washington Post at some point? So just realize not only is it subject to the Public Information Act to disclosure, it's also a fairly permanent, or could be a fairly permanent comment. It's very easy for people to forward this and say, oh, look what this person said. Yes, that can always be, it's possible to change it so that just even if you say something innocent, somebody could add something in there, in a mean sort of way. But just be careful with texting and emailing, and if it's as we've been saying, if it involves deliberation, it's going to be subject to the Open Meetings Act, and if it's among a quorum, let's just make sure that's handled in an open meeting, and not by email and not by text.
Okay, thank you. Okay, if during a virtual meeting, a voting member in attendance was to fall off the meeting call, I'm guessing that means technical issues, but comes back on shortly thereafter, what would be the proper and most appropriate way to address this if it occurs during a vote, any other general time, and in the minutes?
I would say that's a practical question as far as how long, in terms of affecting the minutes. I would say every other meeting that we've had the last 18 months, something's going to happen. You're going to have somebody drop off for a short time. If you have a sufficient quorum and somebody is off for a couple of moments during a vote, well, that can happen. They've already heard the presentation. That shouldn't be a problem. Even if there's a slight dropping off for a moment or so in the presentation, as long as that member feels that they have heard sufficient information and have a documentary record of whatever's being decided, there shouldn't be a problem, and there's generally not a need to note that in the minutes. Now, a more extreme example may be, let's say you have a bare quorum, and in the middle of the discussion, somebody drops off for not a few quick moments, which was the question, but let's say it's more like 15 minutes, and they miss an entire presentation, and then they come on. You didn't have a quorum present for the presentation in that particular case. My recommendation would be, look, redo it, because otherwise you didn't have a quorum present, or that person could always review the information that was presented, and then just put that agenda item on the next meeting and cover it that way. But if it's a fair, and usually with the computer problems, it's fairly quick, or there's a freeze up for a moment. The freeze up seems to happen. It depends on the link where somebody's coming in. It may have nothing to do with the main link at the town or city hall where the meeting's being conducted. It may have something to do with the home where the person's coming in from. And sometimes people are linking in from vacation, and they may be in a resort somewhere, and who knows. Momentary problem is less of an issue, but I would see the bigger gaps. And when you do have the bigger gaps, then the minutes are going to need to reflect that, well, the one board member who was needed to make the decision, because we didn't have a quorum otherwise, was not present. This will be represented, whatever the decision is, at the next meeting. April, I don't know if you have some more to add to that. That's kind of in a virtual setting, it's one of those things that happens.
Yeah. The only thing I would add is that just following up from an open meeting, it is more of a practical question and application. From an Open Meeting Act standpoint, I think all it means is if your meeting starts open, don't close it just because the quorum drops off. I would just keep it open, and that way there's no question that the deliberations are there, the presentation's there, or whatever. And then for the person who dropped off, if the if the meeting's being recorded, that's even better. They can go back and watch it. So, or listen to it. So I think that from an Open Meetings Act standpoint, if you start it as an open meeting, it's intended to be an open meeting, just keep it open even if a quorum drops off.
Thank you. Next question. Can a municipal staff member be designated by the Planning Commission, or does it have to be a PC board member?
Well, remember what we were saying when we went through, that there were two parts of the training requirement. There is one part of the training requirement, I think it's section 213, where a staff member is intended, can certainly be designated. That satisfies a part of the requirement. But there's another part of the requirement that in order to have a closed session, an actual board member must be designated. So designating staff is fine. Probably the more sensible approach, I mean, certainly you can designate staff, but in order to fully comply and be able to have the closed meeting, designating one or more board members is probably the more sensible approach, but the law does cover both.
Thank you. How far in advance can you cancel a meeting due to a lack of quorum in regards to advanced public notice?
I'd say if you don't have a quorum when you're starting, you know, this can happen. These aren't, you know, this isn't thinking theoretically here. This is a reality that can happen to anybody. There can be a snow event, there can be a weather event. There have been instances where, let's say a meeting is to start at 7:30. Bear in mind what we've said, an agenda can be changed as needed. So if your meeting's to start at 7:30, that's the notice, that's the agenda, and you have, let's say a quorum is 3 and you have 2. Well, your attorney is probably going to advise you, and so would we, just hold out there for a minute and wait. And this also happens virtually where somebody needs to log on. The idea would just be to hold out, don't start, and if you have to start 5 or 10 minutes late, then the minutes would reflect. You started at 7:35 or 7:40 because one of the members was not present, or virtually, you know, was not able, it doesn't matter, virtually or in present, if they're not linked in and can't hear and observe what's going on as a board member, really makes no sense to conduct business. The bigger question would be what happens in the middle of the meeting when you have not just one member, but a required quorum drops off for 10 or 15 minutes, or even the rest of the meeting. You know, I think April's advice was good, not to close the meeting. Try to finish if you can, but or at least continue. Hopefully the person will be able to reappear, but just know that with the person being off, the minutes would reflect the board didn't have a quorum and therefore made no decision. And I don't want to repeat what we've already said, but that person would need to, you know, you'd need a representation, or that person would have to watch the video of whatever was recorded.
Thank you. Is there a statute of limitations on the Open Meetings Act?
I'm not aware of one. I know when we heard some complaints, they dated back a year or 2, maybe 3 at most. The problem with that is there's kind of a latches argument that means you waited too long, or sometimes there are proof issues. You can't get, some of the people can't remember, or whatever. The documentation might be there, might not. So I don't know of a specific one, at least for the compliance board opinions. And I'm not aware of one for the court either, but I would think a typical equitable latches argument would apply. Are you aware of one, Frank?
Well, I think the overall courts and judicial proceedings article has an overall statute of limitations that would apply. It would depend on the issue. But generally 3 years is a good rule, but that's when you're before the circuit court. For the Open Meetings Compliance Board, it wouldn't as much be a statute of limitations, but sometimes there's a limitation to say the board's jurisdiction is limited to considering violations or alleged violations over a certain period of time. And I don't believe there is any such limitation. But what April's talking about, the practical, latches is a legal argument that basically you waited too long for this to have any practical meaning. If you have somebody wait 18 months to raise a concern about something, there's going to be less of an interest in and an ability to pursue it, because you have to have the evidence, and at some level the evidence does need to be timely. But I'm actually looking through the elements of the Open Meetings Act and dealing with the board, and no limitation on a timeline of a complaint. I'm not seeing anything. So there's not a strict timeline, but there is a requirement for an annual report, but there's no strict timeline. It's pretty much any complaint. Sometimes a complaint can be recurring. So just the fact that the first instance happened years ago, it may be more important in that case that it's been an ongoing problem.
Yeah, when we saw the older ones that were a year or two out, it usually involved the recurring problem. So they would cite the first one, oh, it happened on this date, and then they would show multiple times. So that's typically where I remember seeing it. And so the statute of limitations didn't come up specifically because it was a recurring issue, but I don't remember any complaint being more than 18 months to 2.5 years old. And it was always in the context of ongoing issues, or maybe not an ongoing meeting, but an ongoing transaction. So some of the developments transactions took over a year to get from start to finish in their approval process. So that's where it might come up also. But again, if the information is stale, and a lot of times the public body can just correct itself and say, oh, well, maybe we violated it then, but now we have these procedures in place. And so the board will look at it and say, okay, so it was violated then, but you fixed it. So we're not going to go back 2 years to go find a violation because you're not doing that anymore. So that's kind of the context it would come up.
The other important part about that is, again, remember, the board is advisory. And so it's less important to have a strict timeline in terms of the board having jurisdiction, because ultimately it's only going to be advisory anyway. In a court setting, if somebody takes that enforcement route, well, the court is not just advisory. And further, in terms of deadlines, do bear in mind there are deadlines. If you get a complaint, you basically have 30 days to respond. So that is clear. But and the board generally responds is to issue a decision within 90 days. So it is important to respond if there is a complaint. But no, it doesn't look like there's any timeline on the board's ability to consider a complaint.
Okay, I know you talked about this one just to make sure that everybody's clear on next steps. This presentation satisfies the MML core requirement. Will our participation be shared with MML? Essentially, I think it's a next steps question for completers.
The compliance information, actually, the more important thing is sharing it with the Academy for Excellence in Local Government. And I believe the process does involve, once all that's certified, because it's the Academy that issues the certification. And if there's a question whether you have been certified or not, it would be the Academy folks that would help. MML or even MACO folks, the Maryland Association of Counties, may be able to get you to that point, to lead you in that direction, but it would be the Academy dealing with that. And they do have the records of your certification. You also should either be able to download, or you should get an email, I would hope, with a link to your certification one way or another.
Thank you. Are there any findings about closed meetings being hacked?
I mean, if that did happen, that would be a matter of a confidentiality concern. I'm not saying that there isn't something, but in terms of the Open Meetings Act, it just wouldn't be something covered there. And the issue, in hacking then would kick into the right of confidentiality. And that often becomes a matter of forewarning or knowing in advance or willfulness in terms of trying to prevent it. And then certainly the person improperly hacking in, to the extent that can be enforced and you can find out. But that's not part of the Open Meetings Act. That would be more a confidentiality, right of confidentiality. Mm-hmm.
Hello, April and Frank. This is John Coleman. Joe had to walk away. I'm going to ask the next question. Is accessibility to hearing and or vision impaired required for open meetings?
That question actually came up at our last session. There is none, but I think it would be based in part on your audience. If your particular body involves a population that has accessibility questions, then maybe you need to provide an ability for them to get notice of the meeting and an agenda in a format that they can hear and or observe the deliberations. Although having said that, I'm not aware, there's no specific requirement that they do provide that type of accessibility.
Yeah, and in a given setting, there could be an ADA requirement, but in terms of the Open Meetings Act, that's not part of what's enforced by the Open Meetings Compliance Board. And that's not part of the Act formally.
Okay, thank you. Here's a next question that is being asked by Michelle Bradley. And it says, can commissions take votes in between meetings on permits? And then she adds, via email.
I would say probably not. That sounds like public business to me. Many times, I mean, there is a distinction, there may be a distinction between, because when you're referring to a permit, sometimes a permit is simply something under the context of your local law that is issued by staff to simply allow somebody to build a building or put up a shed or put up a fence. And if it's in that context, if it's issued by staff, then that wouldn't be required. But if your local law brings it to the commission and it's a commission decision, that local law has made it public business, at least for that public body. And there's any zoning matter, and specifically permits and licenses are all going to have to be part of the open meeting. So the big issue there would be, is it part of what the board has to do? And it can certainly be, the board could say by email, yes, put that on the agenda. That might be reasonable, but the final decision should be made at the board meeting.
Thank you. Okay, 2 questions left. If a large public turnout is anticipated, what are your recommendations on how much physical meeting space must be reasonably provided in light of COVID-19 considerations where a meeting is also being broadcast virtually and via a conference call.
Yeah, that was actually a decision not during COVID, but prior, where there was a large public attendance anticipated, and the public body did not get a room large enough and was just turning people away from the meeting, saying we didn't have enough space, and that was considered not adequate public access for public observations of the deliberation. So what was recommended, if I recall, in that decision was either they should have scheduled a larger room that could have accommodated the size of the crowd, or an alternative could have been an off-site remote location where it could be video monitored and you could view it from that remote location, or in the context of the post-COVID use of video conferencing and audio communications via telephone call-in, you could also have a hybrid scenario, which we've seen a lot of over the past year and a half, where you have a public meeting that is live streamed with a call-in option, or Zoom meeting as part, and the meeting's being held in a room, but then there's a Zoom option. There could be a cable video option. So there are different ways you could do it in a hybrid setting that would satisfy the Open Meetings Act requirements.
Yeah, the main emphasis is on making it reasonably accessible. So being surprised is not going to be an Open Meetings Act violation, but regardless of what else is available, if you know in advance that you're going to have a very large number of people attending in person, then taking some steps, and that's what April was saying, you need to take some reasonable steps to accommodate them.
Thank you. And last question. Can you talk about Planning Commission site visits and OMA compliance?
Yep. I would say that does come up, and a site visit is not an exclusion. That is, think of that a little bit like when I was talking about a retreat, and my emphasis on talking about a retreat, because many times there's an assumption, well, if we're just doing a retreat and planning out for the next year, it's a closed meeting. No, it's not. Not unless that retreat is only about confidential items and then you walk through the processes, which we won't go through again. But in a situation like a site visit, many, I believe state law the state land use code, I believe, encourages it. It's certainly a very sensible thing for commission members to do. If they individually take a look at a site, it's not a quorum. That's not going to be a problem. But if a quorum attends, they're looking at public business. They may not be discussing anything. There may be no deliberation, but they are certainly reviewing matters of public business. There's no exception available to say that can be closed. So the most sensible solution would be, again, what's the first step? Notice. Letting the public know that a quorum of the Planning Commission will be attending whatever site. They may, typically, if you're going to have a quorum attending a development site, they're going to get some sort of a presentation, even if it's informal. Well, that's going to kick in the need for some minutes to be provided, but as well as public access to see the same thing. And that's simply saying, well, we're going to have people are going to have to realize it's a limited space and there's not a lot of room available. But if somebody is interested in coming along, or one or two people, when you're doing a retreat, it's usually not a matter of needing to have an entire conference room available for an audience to sit and watch, but instead to at least have some accessibility for 4 or 5 members of the public perhaps. And for a site visit like that, at least having the availability for 2 or 3 members of the public if they're interested. And that may end up being neighbors. So you might end up having 1 or 2 who would want to attend as well. At the next meeting, then there should be a report in terms of adding that into the minutes, so that then it's you've done an announcement, it was handled as an open meeting, and you did the minutes afterwards that would cover it. Of course, I don't want to say it's an easy solution, but if a quorum is not involved, in other words, if you have a 5-member board and either 1 or no more than 2 go at one time for a site visit, it may be reasonable for them to announce that, yes, I did do a site visit on my own or with 1 other member, but there's not going to be an Open Meetings Act issue because you don't have a quorum.
So I wanted to actually add, we did exactly those 2 examples recently with one of the bodies I advised. We had a situation where there was acquisition of a building, and it needed to be looked at to see what the repurposing of this particular building. And it was part of the meeting to go over there and walk through and look at it and see the status. And there were a few people in the community that wanted to come along, and said that it was noticed as part of the public meeting and the agenda that would be part of the meeting, and it was within walking distance, so it worked out very well, where they would walk over, take a break from the sitting portion of the meeting, walk over and take a look at it and go back. So that's how we handle that one. And then another one, we had a situation where there was going to be a public body was requested to come into a private community to be available for question answer kind of scenario. And not knowing what topics would be addressed, there was concern that if the full body were there, it would be a public meeting, but this particular community doesn't allow outside access for different reasons. And it was creating a little bit of a conflict. So we decided to just do 3, our quorum is 4. So we would have had 3 members. So we didn't violate the quorum. So even though 4 wanted to go, one of them said, no, I'm going to sit out this one, and then I'll go to the next one if there's another one. So yeah, that's how we use both examples that Frank just gave in the last 2 or 3 months. So that's a very effective way to stay in compliance with the Open Meetings Act, and not have to follow it and then the way to follow it if you do include the public. So if it's subject to the Open Meetings Act.
Well, April and Frank, thank you so much. This training also always generates a lot of questions, and we appreciate you providing this training at the MPCA conference every year. I'll be sending out more information and links to everybody in attendance so they can follow up and ensure that they get credit for taking this class. I'll also be posting the recording and the slides on the MPCA website. So, as always, thank you for getting the MPCA conference kicked off so well, and we look forward to continue working with you.
Okay,
Thank
well,
you.
thank you.
All right, and for everybody else, we will be joining a few minutes after 11 for introduction from MPCA President Danny Winborn and Secretary of Planning Rob McCord. It looks like we run into our first technical issues. Danny, we can't hear you. I don't know if you're recording or if your audio is not coming through, but I cannot hear you.
Or can you hear me now?
There we go. There we
All
go.
right. All right. Well, let me start over, okay? I'm sorry to be the technical issue, but we're here, and that's all that matters. So, again, my name is Danny Winborn, and I am the MPCA president, and I'm so happy to have all of you all here with us today and over the next couple of days. This is our 38th annual conference. We had planned to do it in person, but the Delta variant unfortunately caused us to err on the side of caution. So we're doing it virtually this year. So we're hoping that next year we can do it in person. We had a great conference scheduled in person. The Calvert County Planning Commission and the Planning Department were working diligently to put something together. And I did want to thank them, and I'll thank them in a minute, but I did want to remind everyone of our theme, which is let's get back to it. And whether we do that virtually or in person, we're going to get back to it. So we're so happy to have everyone here. I want to thank Frank Johnson, Esquire, and Miss April Ishak, Esquire, for just giving the Open Meetings Act training that just ended. I'm hoping that everyone took advantage of that and learned from that. I did want to, as I said, thank Calvert County for their hard work. I wanted to especially thank Steve Jones, Chair of the Calvert County Planning Commission, and Paul J. Conover, who is the Planning Commission Calvert County Planning Commission Administrator, for their work putting things together. And as I said, we hope to get back to it next year in person. And I'm going to thank some other people tomorrow, but we'll do that tomorrow. I just wanted to acknowledge and thank our sponsors: the Maryland Department of Planning, American Planning Association Maryland chapter, and the Brick Industry Association for their generous sponsorship of our annual conference this year. As I said, we just had our first session, and we have plenty great sessions planned for later today, I believe, and then we have sessions on Tuesday and Wednesday. So I hope that everyone enjoys everything. And if there's any feedback that you want to share with us, we'd love to have you share it with us. We only want to make this better, and we want to make sure that we're presenting the right kind of information to you, and you are actually benefiting from the information that we have. So again, thank you for joining our 38th annual conference, and I'm going to turn it back over to Joe and oh, there's Rob McCord. Hi, Rob. How are you? I'm going to turn it over to you. I'm going to mute myself.
Thank you, Danny. Secretary McCord, I think we're also having difficulty hearing you right now.
There you go. Can you hear me now?
Yes.
There you go. Thanks, guys. Well, I'll be the second one to welcome you to the Maryland Planning Commission Association 38th Annual Conference. Of course, the theme is Let's Get Back to It. I think it's fair to say that for many of us, the work that needs to be done when we're looking to the future of our communities, it never really stops. We can't stop the future, but we can shape it. Our choice, when we consider the interaction of the built environment and the natural environment, has always been between haphazard and patchwork, or thoughtful and planned. The bumper sticker that we need is not the one that the Navy sometimes uses that says, ship happens. We need a bumper sticker that says, tomorrow happens. We don't really have to be reminded of that, but other people may need to be reminded that tomorrow will happen, whether we plan or not. We've become a bit better at using technology to bring us together, even if some of us are wearing sweatpants. I'm not going to ask. Who knew that those of us who watched the Brady Bunch back in the day were not just looking at an architect and a blended family, but we were getting a glimpse into the future of our lives on Zoom, where everybody appears in the square. We need to continue to plan for the IT infrastructure that will allow this to happen easily for more of us. Expanding broadband access is a challenge that we need to meet successfully. There are issues of coverage, right-of-way, and zoning that remain, but these are solvable when we are thoughtful and we are collaborative. One of my roles as secretary is I'm also the chair of the Maryland Heritage Areas Authority. Knowing our heritage is important. Heritage tourism benefits communities all across the state. Hold on a second, I've got to ignore a phone call. There we go. Heritage tourism, it benefits communities all across the state. The benefits are not just economic contributions. The benefits include the uncovering and refreshing of our collective memory, where we've been, and what we're going to do with our future. So at MHAA, we're committed to telling more of the stories of the state whose people are more diverse than its geography. The U.S. Census Bureau lists Maryland as the 4th most diverse state in the United States. And Maryland is now a majority-minority state. You can find all of the details, all of the maps, charts, and graphs for your county on our state data center website. And there are links there to go to the data visualizations that the U.S. Census Bureau has provided, which are very good also. In the coming months, you'll also be hearing about the Maryland Semi-Quincentennial Commission. It's a long word, but we plan for that celebration of the country's 250th birthday. We will be known as Maryland 250. We have quite a story to tell about the part we played in birthing this nation. This will not only be about 1776, it will also be about how we've grown as a nation. We also have a responsibility to tell how the blessings of liberty are still continuing to unfold. So each county, all parts of this state, it's not just the birthday party that says we're 250 years old. It's how we've grown up since 1776 and how much growing we have left to do. During the conference, you're also going to be hearing about reducing flooding and climate change. These topics will always be with us, and we need to adapt our planning strategies to account for them. We need to keep our perspective wide and consider applying every lesson that we've learned from wherever success has been demonstrated. We can't keep following the same old formulas, expecting different results, of course, but every time we share those best practices between each other, where we demonstrate that something actually worked, that's what we have to share. So I'd like to commend our team at the Maryland Department of Planning, especially the Planning Services Division, their ingenuity and adaptability to ensure this conference took place and every other webinar we've put on has taken place, regardless of shifting virus mutations and all the attendant uncertainties. As you gather virtually to touch base as planning commissioners, please know that I appreciate and admire the work that you do. I hope that you find something in this time together that's beneficial and something that just inspires you to leave the place you care about most better for the future. Whether we plan or not, tomorrow happens. So thanks for letting me say hello and enjoy your time together.
Well, thank you, Secretary McCord. MPCA President Danny Winborn, thank you very much for kicking us off. I just want to point out to everybody that we will be starting up again tomorrow morning, bright and early at 9 o'clock. And we have 2 full days of excellent educational resources, very experienced panelists, as well as a annual meeting from the MPCA Executive Committee tomorrow during the lunch hour, which will at the end of that, we'll be talking about 2022 initiatives, which are very exciting, and we're looking forward to working with the membership to make those initiatives a reality in the upcoming year. And then on Wednesday, during that same lunch hour, we'll be celebrating the work of and recognizing the work of some excellent citizen planners in the state of Maryland. So we hope you can join us for that as well. On Wednesday, we have 3 sessions, that will be eligible for AICP CM credits. One of them is being conducted by our close partner and sponsored APA Maryland chapter. So we hope that you can join us those, but we really want you to be able to join us completely for the next 2 days. The MPCA was really, as Danny mentioned, and as I will probably repeatedly mention, the MPCA was really excited to be able to, hoping to do this one in person. And we regretted that we had to go virtual, but in the end, the MPCA Executive Committee decided it was the best choice. And we sincerely want to thank Calvert County and can't wait to being able to host our next conference in the county. So everybody, happy Monday. We will see you the next few days. Again, thank you, Secretary McCord and Danny. And yeah, it's going to be a great couple days. Hope to see you all here. Back.